Nice to be here again. This has been a delightful conference so far. I want to thank Leslie again for putting it all together. I have learned a lot and look forward to learning more as the day goes on. I'm moderating this session. It only has one speaker because this topic is pretty interesting, and we invite audience discussion as we get farther along. Our speaker for this session is Mark Rothstein. He holds the Herbert F. Bohl Chair of Law and Medicine and is director of the Institute for Bioethics, Health Policy, and Law at the University of Louisville School of Medicine. Professor Rothstein has concentrated his research on bioethics, genetics, health privacy, public health, and employment law. And for 1999 to 2008, he served as a member of the National Committee of Vital Health and Health Statistics, and chaired the subcommittee on privacy and confidentiality. He is past president of the American Society of Law, Medicine, and Ethics, and a fellow of the Hastings Center. And we really look forward to his comments during the next session.
Thank you, Joyce. Good morning, everyone. I want to add my thanks to Leslie and Marjorie and to all the others who made this meeting happen. It's a terrific meeting, a great opportunity, at least for me personally, to catch up with some of my NCVHS friends who I haven't seen in 2 years, as well as my academic colleagues. Before I get into my talk, I want to say a few things about some of the comments that were made in the last session, and I didn't want to take time from their session, so I took it from mine. To explain a few more things that may not be as clear, and then get into the issue of genetics and sequestration. The first one is the question of how much should the individual be able to delete, amend, sequester information in their own health records. In 2006 and again in 2008, the NCVHS took the position that we can't give patients line item veto power over their health records because that would turn EHRs into PHRs. And then these records would not have, have the trust of the clinicians. They would have to retake histories and stuff like that, and it would defeat the whole purpose of EHRs. So even though NCVHS supported the concept of giving individuals a degree of control, it was clearly the thought that we can't let them go down to the item level in those controls. The second point, and this relates much more closely to my comments today, is goes to Walter's talk, and that is a question of what is the state of the current EHR systems? How good are they? How well can they accomplish the goal of identifying and sequestering sensitive information, whatever we define that to be? And the answer to that question from my research, my interviews with numerous vendors and talking to the system architects is not very well. And the reason for that is it's very expensive to build into the system, and there's no demand to do that at the present time because it's not legally required that they offer the kinds of things that we're talking about. Now, over time, it may well be. But their clients aren't particularly interested in this now to begin with. And so when there's greater demand and perhaps a legal requirement, they'll do that. There are certain features that are available, but if you look further into them, they lack the granularity to make them meaningful, and I'll talk about how you figure that out. And the last comment I want to make really addresses Sharona's question, and that is how do you avoid the problem where you sequester information, let's say mental health information, and now somebody's taking some powerful meds, and how can the clinician gain access to that without gaining access to the sequestered information? Let's say you're treating somebody for a sprained ankle and you want to prescribe painkillers, but there's this interaction. And the thought of the NCVHS and our witnesses who testified at the hearings a few years ago was that it could be possible to design clinical decision support that would review both the open portion of the file and the sequestered portion of the file, and then produce an error message of some sort. But we don't need to explore now exactly what that error message might be. Well, the topic I want to talk about this morning is a subset of the things that we've been talking about for the last several sessions, and my focus is on genetic information and how you sequester sensitive genetic information in EHRs. And let me see if I can start by bringing together 4 strands of information that points in the direction to where I'm going. And the first one is from the NCVHS letter of February 2008 that Maya would have showed you and wanted to show you, but it sneaked its way into my presentation. And that is recommendation 1A. The very first recommendation in this letter said the design of the NHIN should permit individuals to sequester specific sections of their health record in one or more predefined categories, and those categories would be well known. They would be nationally recognized categories. The elements of those categories would be understood. And the examples that were included, not necessarily the categories, but the examples were domestic violence, genetic information, mental health information, reproductive health, and substance abuse. Okay, the second strand comes from the Stimulus Act, or the High-Tech Act portion of it, Section 3002. Here, Congress specifically relied on the NCVHS letter of a year prior, and in the section in which it set up the HIT Policy Committee and said what this policy committee should do and listed 8 various things, the number one thing on the list was the sequestration. So technologies, this is what they should consider: technologies that protect the privacy of health information and promote security in a qualified EHR, including segmentation and protection from disclosure of specific and sensitive individual identifiable health information. So that was the number one thing that was included on the list. So that's the second of the 4 strands. The third is the Americans with Disabilities Act. And for those law students and professors who are familiar with the ADA regulates the way in which employers can conduct medical examinations by basically splitting the employment process into 3 broad stages. At the first stage, the pre-employment stage, an employer is not allowed to make medical inquiries. The theory being that individuals with disabilities should not be disqualified from consideration before they have a chance to present their abilities. At the far end, examinations of current employees have to be either voluntary or job-related and consistent with business necessity. So you can only give medical examinations of current employees to see if they can do the job. But this middle ground, the so-called pre-placement examination, after individuals get a conditional offer of employment, the employer says, you look great, we're prepared to hire you starting May the 1st, conditioned on you're getting a good examination result from our examining physicians. At this point, the examinations can be of unlimited scope, regardless of the nature of the job that the individual is applying for, and as part of that examination, the employer can require that the individual sign a HIPAA-compliant authorization releasing all of their medical records to the employer or the employer's designee. Okay, so that's Section 102D3. So that's the third element. And the fourth element is GINA, the Genetic Information Non-Discrimination Act. Title II deals with employment. Title I deals with health insurance. First, I want to say a little bit about the definition of genetic information, because we have to consider that. And it says that genetic information in 2014 says the individual's genetic tests, the genetic tests of family members of the individual, and third, the manifestation of disease or disorder in family members, in other words, the health history of family members. Now, one of the things that you might notice very clearly is it doesn't take into account the medical condition, the manifestation of disease or disorder of the individual. Even if the individual has a, quote, genetic disorder, that is not genetic information under the Act. And that's the main flaw of the statute, that is in Title I with regard to health insurance, so that it's unlawful to discriminate against you if you are genetically predisposed to X, but now you get X, well, that's too bad. And it's not a flaw of GINA per se, it's the flaw of our healthcare system. Because if they corrected GINA, that would mean basically that people who were already sick could show up and get individual health insurance policies without medical underwriting. And I believe some people are still discussing whether that's a good idea now, okay? But that's the hole that's been created by GINA. Now, the other provision in GINA is Section 202B, dealing with the acquisition of genetic information. It says, it shall be an unlawful employment practice for an employer to request, require, or purchase genetic information with respect to an employee, which the statute defines to also include an applicant, or a family member of the employee. So let me put these four strands together if I can. So reading the ADA and GINA together, after a conditional offer of employment, an employer may require a medical examination, including access to an individual's medical records, except, now here's the GINA part, except records containing genetic information. Okay. Now the second part is reading the NCVHS letter along with what Congress said, and of course the NCVHS comes first before what Congress said. Individuals should have the ability to sequester certain types of information, including genetic information in EHRs, and in the letter it was couched in terms of the NHIN only. And technologies to permit this should be among the recommendations to ONC, which is what Congress said. So the question is, how can you do this to facilitate the goal that was set out, or the legal requirements now, in the ADA and GINA? Now, at this point, I have to confess to the audience, I'm going to do something that you should never, ever do. And it's such a terrible thing to do that I predict that Jeff Botkin will walk out in the middle of my talk. No, he's here. He's still here, but he will walk out in the middle of my talk. And what I'm going to do is to describe to you a grant application that I filed February 5th with NIH. They won't even consider it until June. And now I'm going to tell you what it is. And the reason why I do this is I'd like to be funded, but I don't really care all that much. The point is that if I don't do this research, somebody else needs to do this research. If it's not me, it's maybe some HHS agency. And if it's not HHS agency, it's maybe some researchers out in this audience. This research, and I hope to convince you of the importance of it, needs to be done, and it needs to be done right away. GINA requires the use of existing technologies that don't currently exist, and there's no feasible way for covered entities to comply with GINA. So what happens currently is when somebody applies for a job and they get this authorization, they may or may not qualify the authorization by saying send everything but, oh, by the way, don't send genetic information. Now, imagine you are the medical records department at a large institution or just a small provider's office. How in the world are you going to pull out of a paper record, even an electronic record, family health history and things like that? You can't do it by and large. And in many instances, everything goes. So there's really no compliance with GINA. Demonstrating the ability to sequester genetic information in EHRs, which I would hope to be able to prove, I think would point the way to developing other technologies, because we don't need to just comply with GINA, we need to comply with all sorts of laws, and also give some force to the ethical discussion that we've had over the last couple of days. Why is this important? because EHRs are increasing longitudinal and comprehensive. That means they've got more stuff in there, and the more stuff in there, the more likely there is to be something that people would consider sensitive, whatever that might be. And it may have no clinical utility. It may be 20 years old. In fact, it may be something that current providers don't even care about, wouldn't have the time to look up, but just knowing it's in there is problematic to individuals. And it might deter them from seeking treatment for some stigmatizing condition. EHRs are routinely available to every healthcare provider. A lot of times the focus of the discussion is on physicians, but it's not just physicians. If you're going to make health records available, they're available to dozens of different providers, regardless of reasons for their access and regardless of their need to know. And also, EHRs are routinely required to be disclosed in the employment setting, as I mentioned, but many other areas as well. In a study that we did a few years ago at my institute, we tried to estimate the number of compelled authorizations. That is, you want to apply for a job, you want to apply for life insurance, you have to sort of sign away access to your information. The most conservative figure that we could come up with was 25 million times a year. And these disclosures are not normally restricted in scope, and even when they are restricted in scope, in many instances the entire record is sent. So this is a very important issue in terms of protecting privacy. So here's this proposed research plan. We wanted to do research on genetic information. Excuse me. So where are you going to find genetic information? Mixed in, I'll get that later, I promise. Maya, your days of assisting me are over. Okay. So where are you going to get a combination of genetic information and non-genetic information? We thought that OB-GYN records were a marvelous source. It contains lots of genetic information, the results of, amnios, prenatal testing of individuals, genetic histories, family histories of affected children, and so forth. It also contains lots of other sensitive information, right? Sexual information, abortion history, infertility, you name it, it's in there. But they're also primary care providers, and so you've got lots of other kind of routine stuff in there. Can you tease that apart? So we located a practice, 6 physicians in the Louisville area. They have 30,000 patients. The patients remarkably mirror the demographics of the community. They've been using EHRs, in particular the MISIS EMR system, for 7 years. And they agreed to assist us with this project. Now, technically, we don't need to get informed consent from the patients because we're going to de-identify their information before we do anything to them. But I'll be doggone if I'm going to, this allegedly privacy person is going to take the most sensitive information you can find and sneak in around what I consider to be an ill-advised provision of the common rule to get access to these information without informed consent. So I called the chair of our IRB and said, we'd like to get informed consent for research on stuff that's exempt under Exemption 4. Would you review it? And, and he said, I think that's the first the request I've ever gotten to review research that's exempt, but yes, we will do that. So we're going to get informed consent from 600 patients. 200 of them, and this is a sub-study on informed consent. I thought I'd take the opportunity to do another study at the same time. 200 of them are going to be recruited by their treating physicians, 200 by nurses in the OB-GYN practice, and another 200 by the nurses employed by this study. The eligibility criteria, anybody can be recruited as long as they're 18. They'd never been recruited before, and they weren't at their first visit at this practice. We're going to use 300 records, and the first step will be to have our contractor de-identify the record according to the 17 HIPAA fields in 164.514B. Our contractor is Emergent Technologies of Louisville. And they will extract the MISIS EMR into an XML standard HL7 CCD format and use their own proprietary de-identification programs. And then at that point, we're going to have two teams consisting of one genetic counselor and one nurse working together to review the records. And they will have undergone prior training, and I'll spare you what that involves. And then they will highlight wherever they find in these 300 medical records genetic information that satisfies the GINA definition of genetic information. The highlighted de-identified EHRs will then be loaded in a secure domain on the Talvin Semantic Wiki. And if you're not familiar with that, Talvin is based in San Francisco, and they have a lot of open source materials. What we want to do in particular is make all this research open source. And so we're going to initially put the EHRs in a secure domain to which only the investigators have access. Talvin will also load on its wiki the following sources for vocabulary encoding. And one of the problems with some of the other available products is they may use one of these, but not all of them. And so we're including SNOMED, LOINC, RxNorm, ICD, the whole 9 yards. All the coding and mapping tables and vocabularies are going to be loaded on this. And then at this point, 3M Health Information Systems Division, anybody here from 3M? Because they're based in Murray, Utah. They're our contractor, and they're going to take this highlighted stuff and translate it into clearly recognized vocabularies on one of these alphabets. And at that point, once we've got the coding, our other contractor, Emergent, will take the codes developed by 3M and create the algorithms to capture the coded terms in the EHRs. Now we need to test that. So we take the algorithms, we apply it to the records, we run them through that filter, and then we bring back the study nurses, and they're going to do side-by-side comparisons because they're going to have the original de-identified but original EHRs and the filtered EHRs, and they need to make sure that all the genetic information is removed but no non-genetic information according to the definition under GINA. If unsuccessful, then they're going to go back and redo it again. And assuming that it is successful, the coding data developed by 3M and the computer applications that were developed by Emergent will be loaded in the publicly accessible parts of the Talvin Wiki to allow open source development and application to other systems. We've also been in contact with people in the industry who have agreed in principle to take over this site and support it after the end of the grant period so that software developers from all the major companies can continue to use this and use this open source and try to apply it to their product. So this is just a sort of a flow chart. We start with the informed consent of the patients, then we download the files and de-identify them. The nurses highlight the genetic information. It goes to the wiki. Then 3M creates the coding. Emergent uses the coding to develop the algorithms. Then we test that. And at the end, we disseminate our findings, both in terms of publications and also really my goal would be that at some point perhaps ONC would sponsor a conference inviting all the developers and all the software people and all the privacy people and anybody who wants to spend the day in the Humphrey Building to this meeting where we try to figure out, okay, how are we going to make this work in the genetics area, and how are we going to now take it to all the other areas? Because genetics is a nice example because what we're trying to figure out how to do is legally required, but it's also the easiest case, which is another reason why I wanted to start there. There are some other areas that they're unbelievably complicated. And let me just highlight some of the personnel. Brad Mallon, Brad, you heard from yesterday, is one of our technical advisors, and I'm sure a lot of the HHS people remember Bill Yasnoff, who's another one of our technical advisors. And so we've got some really smart, knowledgeable people who know a lot more about informatics than I do, which is a very good thing, who are going to advise us on how to do it. As I said earlier, if this is not funded, fine. Somebody else has got to step forward and demonstrate that it's technically feasible to do this. Now, as you've heard, we've been holding, I still say we, NCVHS has held hearings on this issue since 2005. And one of the things that we get are, well, not only is it a bad idea, but you can't do it. I'll deal with the bad idea separately. It's nice to be able to say, all right, it may be a bad idea, but I've proven that we can do it. Now let's debate whether it's a bad idea or a good idea. And so I think it's very important for somebody to develop some sort of software applications that can actually do this. Because at the moment, GINA is an empty promise in terms of protecting the privacy of genetic information when it's shipped out to employers at the pre-placement stage of the process. So I deliberately kept this short so that we could have a wide-ranging discussion, and I'd be happy to entertain your questions.